good evening, and a very warm welcome to Thorough Newspaper Analysis. Now, today is 3rd of August, and this entire video series it's brought to you by LawSikho. Now, let's proceed to the agenda quickly. So, first, we discuss this article, which is titled as "The Dangers in the Digital Personal Data Protection Bill." Here, the scope of this discussion around this article would be this: the authors there they've highlighted some issues with the draft that was released by the government for public consultation, and the authors are hoping that those the bill, if it translates into an act, then it addresses those glaring gaps before it is converted into an act, and it becomes the robust legal mechanism for governing data protection law in our country. Secondly, we talk about the important news updates. And thirdly, we have a look at important legal updates of the day. So, with this, let's dive into this article and let's start with the why of the article first. See, recently, the government it is now all set to introduce the Data Personal Protection Bill 2023 in the Indian Parliament, 2022 in the Indian Parliament. Now we know that in November of last year, the government released the first draft of the bill for public consultations, and then it was noted by a lot of policy experts in the domain of data privacy and others that there were some glaring gaps in the draft that needs to be addressed in if we want to have a very robust legal mechanism which is balancing the interest of all the stakeholders and safeguarding the personal data regime of the public. So now the authors are saying that it is imperative that before this bill translates into an act, all of these gaps they are addressed. Let's understand as to what are the repeating errors. Before that, we need to get this one picture clear. See, we are a democracy, and in democracies, in order for us to hold our governments accountable, it is so important for us to get access to the right pieces of information. And at times it so happens that in the interest of the public, disclosure of personal data is also warranted. Now, if I were to give you an example, the Supreme Court has held that citizens have a right to know the names of the willful defaulters and details of NPAs, which is non-performing assets of the public sectors. Similarly, democracies, often what we do is we disclose or we do a public disclosure of voters list. Now, a voter list, we know that it contains a lot of personal data. Let's say your name, your address, or other personal data attributes. Why is this disclosure made? Again, for the greater public interest, greater public good, which is so that the public has a scrutiny and the public is able to see that there is no electoral fraud committed behind the tables, behind the curtains, and there's transparency which is maintained. Now, what Data Protection Bill 2022 is doing, it is bringing an amendment, proposing an amendment to the Right to Information Act, which we know it has empowered so many of our citizens since its enactment in the year 2005. Now, within the RTI, there is a section which is Section 8, subsection 1, clause J. What this section does is it harmonize people's right to information with their right to privacy through an exemption clause. So what this section does is, what this clause does is, it says that personal information, it is exempt from disclosure. So let's say if I have sought any piece of information which is in the nature of personal data of someone, so then there is exemption from disclosure of that personal information, but there is no blanket exemption. It is not saying that, since it's a personal information, so we are exempting and you cannot get, disclosure of this information. Rather, there are some riders, there are some clauses, caveats. So it says that there is going to be exemption from disclosure of personal information if it has no relationship to any public activity, if it has no relationship to any public interest, if it has no information sought which is such that it would cause unwarranted invasion of privacy, and the information officer is also satisfied that there is no larger public interest that is justified from the disclosure. So if had there been a larger public interest justifying the disclosure, then disclosure would have been given and there would have been release of the data. However, what this proposed amendment does, it puts a blanket exemption. The enactment of this data protection law, it does not, although require an amendment in the existing RTI Act, which was also stated by Justice AP Shah report on privacy. But what it is doing is it is giving a blanket exemption which exempts all personal information from disclosure. So this threatens the very foundation of the transparency and accountability regime that we have and we would want to continue. Now, secondly, we know that if I were to ask you, that what is the primary objective of a data protection law, then I'm sure one of your answers would be that it is to prevent misuse of my personal data. Now, we also know that in our country and in other countries as well, government, it has a very huge stakeholder. It is a huge stakeholder, and in in having a repository of data. So, if I were to take an example of Indian government, our Aadhaar details and all of these documents, the government has a very huge, in fact, the biggest data repository, and therefore, an effective data protection law, it must not give wide discretion power to the government, because then it would alter the course of the law to fit and suit its course of action, and then it might contradict with our interest for protection of our personal data. Now, what the bill of 2022 is doing is it unfortunately empowers the executive to draft rules and notifications on a vast range of issues. Now, let's take an example. The central government can exempt any government or even private entity from the application of the provisions of the law by merely issuing a notification. Now, it would create a problem, because let's take an example of this authority, which is called Unique Identification Authority of India, which is responsible for managing all the Aadhaar related database. Now, let's say if the government issues a notification and says that, this authority, government body, it is exempted from the law, data protection law. So, do you see that there is a problem, because then it can be misused? Now, another gap in this act is that there is no autonomy of the principal body which is going to be responsible for implementation of the data protection regime. So, there is this authority which is proposed, which is the Data Protection Board. It does not have a considerable amount of autonomy. Why? Because it is the central government that is going to be at the top of everything. The draft, it does not even make a pretense of ensuring autonomy of the board, which is the institution responsible for enforcement of the provisions of the law. The central government, it is empowered to determine the strength, the composition of the board, as well as the process of selection and removal of its chairperson and other members. In fact, the chief executive responsible for managing the board is to be appointed by the government, giving it direct control over the institution. Thus, the creation of a totally government controlled data protection board, which is empowered to impose a fine which is as massive as rupees 500 crore, it is bound to raise serious apprehension of it becoming another caged parrot, which is open to misuse by the executive to target the political opposition and those who are critical of its policies. So therefore, the authors are departing with a note that these concerns, they need to be addressed before this bill it translates into an act and become, in fact, the data protection regime which our country has been looking forward to for a really long time. And this is, in fact, very important, because given the kind of age that we live in today, we interact with a lot of data on a daily basis. So it's very important that our legal mechanism, it is robust and it balances the interest of all of us. And now let's proceed further. And now we proceed to the national news category, and this is our very first update. The government launches Digital Crop Survey. Digital Crop Survey, it is an initiative of the Indian government to establish a comprehensive and accurate database of crop cultivation across all farmlands in India throughout the different farming seasons or agricultural seasons. The project, it seeks to create a single verified source of truth regarding the farmers and their crop sown data. The survey will collect information on different types of crops. These are sown by the farmers in their fields through an automated process using the georeference maps and remote sensing images. The survey will be launched across 10 states, beginning with the Kharif 2023 season. Now we proceed with sports related updates for today. World University Game double delight for shooter Sift Samra. Sift Samra, she edged Ashish Choksi to win the gold medal in the women's 50-meter rifle three positions. This was at the World University Games. She scored 462.9 games, 9 points, while Ashi she finished with 461.6 pointers as India grabbed the top two positions. Also, Sift Asi and Manini Kaushik. They won a gold in the women's 50-meter rifle three-position team event. The trio they scored a point of 3,527 to take the top position. Apart from this, the men's 10 air pistol team event here, Arjun Singh Chima, Varun Tomar, and Anmol Jain, they also secured the bronze medal, collectively scoring a point of 1,730. Airtel launches self-serving digital marketing product Airtel IQ Reach. Launched under the Airtel IQ, the world's first network embedded communications platform as a service, Airtel IQ Reach, it is an intuitive platform that is going to enable small and medium businesses to make the most of their marketing investments as they engage with target customers in a cost effective manner with prepaid pay as you go plans. India and Moldova, they agree to sign MOU for cooperation in agriculture. The Republic of Moldova, which is a country in Europe, and India, they will collaborate in the field of agriculture. The initiative and the signing of a memorandum of understanding in this regard, it was agreed at between the both parties in Delhi by the representatives of the Ministry of Agriculture from Moldova and India's Minister of State for Agriculture and Farmers Welfare, Shobha Karandalaje. The Indian Army, it implements common uniform for brigadier and above ranks. The Indian Army, it has introduced a uniform regulation for senior officers with brigadier and above ranks, and this is aimed at promoting a common identity and character for the Indian Army. The new regulation, it will see all officers above the rank of brigadier, major general, lieutenant general and general wear breads, which is essentially this cap. So they are to wear this cap of the same color, common badges of rank, a common belt buckle and a common pattern of shoes. The use of the shoulder flashes like in special forces, this will be discontinued. Bollywood art director Nitin Desai, he is found dead. Art director and producer Nitin Chandrakant Desai, he has died allegedly by suicide at the age of 57. According to reports, he was found dead at a studio in Maharashtra and police has prima facie stated that it looks like a case of death by suicide and now further investigation is being carried on. As per a PTI report, Desai had defaulted on a rupees 252 crore loan to its financial creditors, and in fact, very last week, a bankruptcy court had admitted an insolvency petition against his company. Deepak Shenoy, he is honored with the Global Visionary Entrepreneur Award. Dr. Deepak Shenoy, who is the MD of Medic Dragon Private Limited, he was felicitated with the Global Visionary Entrepreneur Award for the year 2023, and this was at the sixth edition of the South Asia Pacific Healthcare Summit and Business Award 2023. This was organized by the Brands Council, Ratings and MediLinks. Earlier this year, Medic Dragon Private Limited, it was also awarded the most prestigious and coveted most promising company in corporate governance 2023 at Association's national seminar, which was organized under the theme Healthcare 5.0 Enhancing Healthcare Capabilities and Leadership Excellence Award. This happened in April in Kolkata. It also received the Golden Pinnacle Award for Most Promising Company in Corporate Governance and Sustainability Vision Award for the year 2003 in Dubai. Rajya Sabha passes Multi-State Cooperative Societies Amendment Bill. The bill, it amends the Multi-State Cooperative Societies Act of 2002. It establishes the Cooperative Election Authority to conduct and to supervise elections to the boards of multi-state cooperative societies. The bill, it allows state cooperative societies to merge into existing multi-state cooperative societies. The bill establishes the Cooperative Rehabilitation, Reconstruction and Development Fund for revival of sick multi-state cooperative societies. As per the bill, the central government will also appoint one or more cooperative ombudsmen with territorial jurisdiction. An ombudsman essentially is, you can say, a government appointed appointee whose primary responsibility is to seek to address complaints or grievances of the general public against any public authority concerned. So the ombudsman will inquire into complaints which are made by the members of the multi-state cooperative societies. This has brought us to the international segment for today. Cristiano Ronaldo, he has become the highest goal scorer with headers in football. He scored his 145th headed goal, breaking the long-standing record of German striker Gerd Müller. Ronaldo, he achieved the feat when he scored his first goal of the season for Saudi Pro League club Al Nassr with a trademark header in the 74th minute against Tunisian club which is Monastir in a 2-1 win. Ronaldo met the cross from the right at the back post and then he gave the keeper no chance whatsoever in a match of the club, the Arab Club Champions Cup. This has brought us to the legal segment for today with the first update coming from the Honorable Apex Court. So the Supreme Court has held that affinity test, it cannot be applied as litmus test for scrutinizing caste claims. A question might arise in your mind as to what is an affinity test. See, an affinity test, it mandates the study and thereby thereafter, once you've studied, you prepare a report and it is to be done by authorities on caste and tribe claims. Suppose I go and make a claim that I belong to an XYZ tribe, a scheduled tribe. So the concerned authority, it is going to undertake a study. It is going to consider peculiar factors, the anthropological and the other traits, the rituals, the customs, the mode of marriages, death, and all of these factors. And then the applicant is going to be tested on those factors. So if I am a person and I make the claim that, I belong to a scheduled tribe, so then by virtue of all of these tests, it is going to be ascertained whether I have the body structure that is usually a feature of that particular tribe, whether I have knowledge of all of these constituents. So this is essentially an affinity test. So the Supreme Court has observed that affinity test, it cannot be applied as a litmus test during a scrutiny of the caste claims. The bench observed that if an applicant it is able to produce authentic and genuine documents of pre-constitution period showing that he belongs to a tribal community, then there is no reason to discard his or her claim as prior to 1950 there was no reservation provided to the tribes included in the constitution, the scheduled tribes order. This was held by the Supreme Court in the case which is titled as Priya Pramod Gajpe versus the state of Maharashtra. Second update, it also comes from the Honorable Apex Court. So here the Supreme Court has held that only fundamental determinations are hit by res judicata and not incidental or collateral findings. See, I'm sure you know that the principle of res judicata, it is given a physical manifestation in form of Article 11 of the CPC. Section 11 of the CPC. So one of the constituents of Section 11 is that the matter which is directly and substantially in issue in the second suit, the subsequent suit that you bring, it was already in issue in the former suit and the court has given a conclusive decision. The court heard you and then it decided the matter, the issue concerned finally, and then now you're re-agitating the same issue in the second suit, so then that cannot be done and it is going to be hit by the principle of res judicata. Now, here in this case, the Supreme Court has held that only the substantial, the fundamental determinations of the court, they are hit by the principle of res judicata in the subsequent proceedings. And if the court makes any incidental, supplemental, or non-essential observations which are not fundamental but which are collateral to the final determinations, then those collateral determinations, they are not going to be hit by the principle of res judicata. Because you see, in a particular suit, there might be a couple of issues. Now, some of the issues, they are going to be fundamental, they're going to be germane to the proving of the cause of action and establishing your cause of action. And there are some collateral issues on which the court is not required to give any finding as such, to decide or determine or give any finding on the rights of the parties. But the court has, let's say, anyway done that. So that is called incidental and collateral issue. And the principle of res judicata, it does not apply on such issue. The name of the case is Yadea and another versus the state of Telangana and others. With this, we've come to an end of the TNA. In case you want to get access to the free study materials that we provide or the TNA slides that have been used in this video, please feel free to join our Telegram channel. And for the same purpose, you may scan the barcode here or you may click on the link which is given in the description. Also, the quiz which is based on yesterday's TNA, it is made available for your kind consideration in the description, and I would urge all of you to please go ahead and attempt the same. Also, please don't forget to put down your answer in the comment section. Thank you for being with us.